Good morning or good afternoon, depending on where you may be joining us today. Thank you for attending today's presentation, I-9 and E-Verify Compliance, Costly Pitfalls to Avoid. Although this webinar is hosted by CISIV, a global provider of compliance-driven human capital and risk management solutions, some of you may be joining us from one of our family of brands, whether you signed up through PreCheck, DriverIQ, or our other divisions. Thank you for joining us. Before we get started, I want to review a few housekeeping items. Due to the high volume of attendees, everyone will be muted to ensure the best experience. If you experience any issues during the presentation, you can interact with us using the chat pane in Zoom. This presentation is being recorded, and we will share the recording after the webinar with everyone who registered. If you have any questions for the presenter, you may enter them in the Q&A tab, and we will try to address them at the end of the presentation. Today's webinar has been pre-approved by both SHRM and HRCI for 1 hour of continuing education unit. We will email the credit information once the webinar recording is available after today's presentation. Also, please keep in mind this presentation is intended for informational purposes only. Neither this presentation nor the material presented during the webinar should be construed as legal advice. Thanks again for joining us today. Without further ado, I'm excited to introduce our speaker, Kimberley Best Robidoux from WR Immigration. Kimberley, please take it away.
Thank you, and good morning or good afternoon, everyone. I'm excited to be here. I'm Kimberley Best Robidoux. I'm with WR Immigration. I am currently in our San Diego office. We have 10 offices throughout the country, and we do both U.S. immigration work as well as some global work. So it's nice to be here. One of my first things that I did as an attorney was I-9 compliance, and that was in the form of a major audit that was done at a hotel in Washington, D.C., back when it used to be INS, and the officers would come in with their guns in the holster on their hips. So it was exciting, needless to say, but also scary. So that's been one of my things that I've loved to do. So I'm happy that I'm here to speak with you all about I-9 compliance. So we're going to talk about I-9 and E-Verify. Just to give you a roadmap, I'm going to go over a little bit about the one-page Form I-9, the alternative procedure for virtual review of I-9 documents, which is the new procedure that came out by Immigration Service. Also, the increasing list of acceptable documents, and then we'll focus on some information about internal I-9 audits. All right, the one-page form. We had initially, back in 1986, a one-page form. Over the course of several years, it eventually morphed into 2 pages. And then last summer, the Immigration Service released a new form. We're calling it the one-page form. And that is the one with the date of August 1st, 2023 on the bottom left-hand corner. There was, prior to this current version, the version of October 21st, 2019, that had an expiration date on the face of it of October 31st, 2022. That is no longer valid, but also for purposes of keeping in mind, if you're ever doing an internal audit, know that it technically did not expire till October 31st of 2023. Just so that's one thing that people want to keep in mind is the various versions. So the current version is the one that you must be using. And again, that's effective August 1st. This is for new hires, rehires, and re-verifications. Also, keep in mind that this form is available in Spanish, but only for employers that are located in Puerto Rico. While you might be able to use the Spanish version to help individuals read the English version, you cannot have them complete the Spanish version of the Form I-9 unless they are located in Puerto Rico. All right, so I'm going to start here, which is at the very top of the Form I-9. And it's the very top that a lot of us just completely overlook, right? It says, hey, employers, start here, click on this link to find the instructions for the Form I-9. But there's this anti-discrimination notice. And when the Form I-9, I-9 and employment authorization verification was created back in 1986, there are 2 forms under the 2 sides under the statute. One is the actual completion of the Form I-9, and then there's a separate one, which is about anti-discrimination, right? So the government wanted to make sure that, okay, employers are going to be responsible for verifying work authorization and identity, but on the flip side, they wanted to make sure that employers were not engaging in discriminatory actions when completing the Form I-9. This anti-discrimination notice is on the, it applies to the Form I-9. One of the things it's saying that for employers, you are telling the employees that they can provide any acceptable documentation to prove their identity and work authorization. Employers are not to tell an employee specifically what document to provide for completion of Form I-9, nor can employers treat employees differently based on their citizenship, immigration status, national origin. So that would be improper and illegal. One of the things to keep in mind here with anti-discrimination is that it also falls into what we call document abuse, right? Which is specifying specific documentation that an employer will accept, or turning down documentation that is otherwise valid, an employer just chooses not to accept it. Keep in mind that this is overseen and enforced not by USCIS, but the anti-discrimination provisions are enforced by the Department of Justice's Immigrant and Employee Rights section within the Civil Service Division. So IER, as they're known, enforces the anti-discrimination provisions, and they are actually incredibly active. Some of you may have heard about the multi-million-dollar settlement agreements with Apple and Facebook for various issues. So it's really something to take aware of. This also applies with respect to how companies are recruiting. If there's any specific language in there that says that you must be a citizen only, and that's not acceptable for most instances unless there's a specific government reason to do so. So this is actually being enforced by IER. The document abuse fines are ranging right now from $230 to $2,304, and they typically will assess the fine at the higher end of the range. So just something to keep in mind as we move forward. So this is just a vision of Form I-9. You notice that the version date is down in the left-hand corner. This is the version that must be accepted. Like I said, it is a one-page form. And you can see that Section 1 and Section 2 are now on the same page, which is very helpful. So we'll move on to the next slide, please. And we'll just talk a little bit about Section 1. So Section 1 is where the employee provides information about their name, their address, and then what their current status is in the United States. This is what becomes really, really important when completing the Form I-9 to ensure that the employee is checking one of these boxes. And if they are, we call box 3, so lawful permanent resident, that they include their USCIS or A number. And if they're under a box 4, which is a non-citizen authorized to work until a certain period of time, those are our temporary workers. You might recall that on the prior version of the Form I-9, they were referred to as aliens authorized to work. So I'm excited to see that they changed that, because no one is an alien unless they're coming from outer space. So there's just something to keep in mind, that this is Section 1, and then we'll move on to the next slide, please. So this Section 1, as many of you might know, is required to be completed on or before the first day of employment, and it must be completed by the employee and the employee only, with one exception if there's a preparer or a translator. Section 2, this is the employer's side section. So only the employer can complete Section 2. As you can see here, it's the same as the prior version of the form. Essentially, there are 3 fields in List A, and some of you may be fortunate where you've had to use all 3 fields in List A, specifically if you're employing someone who is a student with curricular practical training or a J1 exchange visitor. And then it's really important to make sure, again, that only the employer completes this version or completes Section 2 of the form unless you're using an authorized representative. So as I mentioned, Section 1 needs to be completed on or before the first day of employment. Section 2 needs to be completed by the employer or an authorized representative within 3 business days of the first day of work. We typically refer to this as the Thursday rule, which means that if an employee begins work on Monday, you would complete Section 2 by the end of day on Thursday. So it's 3 business days, but you start counting, 1, 2, and 3 after the first day of work. This form also includes the old Section 3, which I still keep calling it Section 3, which is for updating and re-verification, which is now the Supplement B, right? And that has to be completed by the employer. if you're re-verifying or rehiring. So one of the things that I also just want to reiterate as a practice pointer is that for those e-verify employers, you must still complete the Form I-9. So think of it as the Form I-9 is the foundation that is always completed. And then e-verify is kind of like icing on the cake, right? If an employer also enrolls in e-verify, that would be completed after Section 1, or I'm sorry, after the I-9 is completed. Like I said, we jokingly, we call this a one-page form. Yes, Section 1 and Section 2 are all in one page, but we have moved on, the government has moved on to taking that preparer translator section, which was on the old page 1 of the form, into now a supplement A. So this supplement A only needs to be completed if there's a preparer or a translator. And this could be completed, multiple times in the course of the process if somebody is also work authorization is being re-verified. And then we have supplement B, right? So supplement B takes the place of the former Section 3. And this is for rehires, for a name change, and then for re-verification of work authorization. So keep in mind that if you are re-verifying the work authorization of a current employee this month, and they were hired a couple of years ago, in which case you used the October 2019 version of the form, doing your re-verification, you would now be doing the re-verification on supplement B. So you always want to be using the current version of the form for any rehires, name changes, or re-verification, even if Section 3 on the old version of the Form I-9 has, is blank. Okay, so just keep that in mind. All right, so that was a quick summary of the Form I-9, because I know we want to get to just some information about updates and kind of what's going on in the world of I-9 compliance right now. So we're going to move on to e-verify. And so as I mentioned, the Form I-9 is the foundation, right? And then an employer may enroll in e-verify if they choose to do so. And I'm going to talk about some pros and cons for enrolling in e-verify. So as I mentioned, e-verify is in addition to the Form I-9. So once the Form I-9 is completed, if an employer is enrolled in e-verify, they would then complete the e-verify process. And of course, that also needs to be completed within the 3 business days of the date of hire. So there's a time constraint there, right? So you want to make sure that you do everything timely. So what are the pros and cons of e-verify, and what is it? I'm sure a lot of you know what e-verify is, but it's a web-based system that is controlled by the federal government that allows employers to confirm the eligibility of the work authorization of their employees, right? So this has been in existence for over 25 years now. It was initially a pilot project, and it has really grown, and it now has multiple millions of employers that are enrolled in e-verify. And in fact, the chief of the section that deals with technology and e-verify had reiterated to us during a conference recently that the e-verify enrollment has actually increased since the new version of the Form I-9 went into effect, with the alternative procedure being permitted as an option to review the work authorization and identity documents for individuals. And I'll go into that process a little bit more in our next section. I just wanted everybody to know that e-verify is enrolling more and more employers in as they're taking advantage of some of the benefits that we've seen with the new version of the Form I-9. So what are some of the pros for enrolling in e-verify? Some state and federal government contractors are required to use e-verify. If it's in the contract and it's specified, then you want to make sure you pay attention to the contract and enroll appropriately. Also, e-verify, while it is currently voluntary for most employers, for some states it is required, right? So the states are growing in terms of what states are requiring employers to enroll in e-verify. A lot of times it's if they have a certain number of employees, or in some instances, just if they're doing business in the states. So the other benefit is that companies that are enrolled in e-verify can offer their F1 students who are working based on, after they complete their program, the e-verify enrollment then allows the company to continue to employ or hire someone to be able to work in what we call STEM optional practical training. So initially, when a student graduates from a university or college in the US, they may have up to 12 months of optional practical training to work for an employer. And then they're allowed an additional 24 months under the STEM program if the employer is enrolled in E-Verify. So that really allows individuals to work a little bit longer, especially since a lot of those professional employees that are on OPT or STEM OPT are going to be sponsored for H-1B status. And with our H-1B numbers being very, very low and the lottery being very, very difficult to win, given that it has a 20 to 30% selection rate, being able to sponsor someone under the STEM OPT is definitely a benefit. And that is something that you would want to, obviously talk with internal counsel. The other thing is that, OPT students are exempt from Social Security and Medicare withholding, which means that for as long as they are in OPT and STEM OPT, they have a little bit of a reprieve from taxes in most situations. So that's some of the things to consider. Another pro is that most employers have reported that it isn't that difficult to complete the verify process for each new hire. And the tentative non-confirmation process is a situation where the government comes back and says, well, this social security number or this work authorization document isn't matching what we have retrieved in the Social Security or the Department of Homeland Security databases. So we need that individual to report to us in order to get that corrected. So that, even though that's the tentative non-confirmation, some might see as a con to E-Verify, it actually can be a pro because it also helps employers know that their employees are authorized to work in the US. The other pro to enrolling in E-Verify is that as of August 1st, employers that are qualified employers, which are employers enrolled in and in good standing with E-Verify, may utilize the alternative procedure, which is the virtual review of documentation for completion of the Form I-9. And we'll talk about that in the next section. Some of the cons, right, is signing up to E-Verify or signing up for E-Verify allows Social Security Administration and Department of Homeland Security to audit the company's data. E-Verify's account compliance section reviews the data every 30 days to determine if their normal statistical parameters are met. And if they spot any issues, they could do a desk audit, which is actually a friendly audit by E-Verify. That's where they truly are trying to help understand what's happening and if they can assist in any way. But they could also refer these issues out to Social Security Administration, to Immigration and Customs Enforcement, to USCIS, as well as to the Department of Justice's Immigrant and Employee Rights section, which could result in an I-9 audit by ICE or in a anti-discrimination investigation by IER. So all of these agencies, have memoranda of understanding that, with E-Verify. As I mentioned, IER has been incredibly active. So it's, another thing to just think about with enrolling in E-Verify. It could potentially increase the chances of being audited by one of these agencies. You also want to make sure that you have more than one staff member at the company who is trained to use E-Verify and that they keep up with any of the changes that happen with E-Verify. So it could be costly or time consuming. It just depends on how many employees you're enrolling in E-Verify and how much additional administrative work that adds onto your employee. As I mentioned that, there are tentative non-confirmations. There also could be erroneous non-confirmations of work authorization where there's identity theft, and E-Verify doesn't catch identity theft. So that's just one of the caveats. And again, one of the things that is a con with E-Verify is that if there is a government shutdown, which we've had several threats of government shutdowns in the past several years, we've also had some significant or lengthy government shutdowns. When that happens, E-Verify is not up and running. So that means that as an organization, you would need to keep track of all your new hires that were hired during the government shutdown and then complete the E-Verify process once the government is back up and running and you can access E-Verify again. right? So those are the pros and cons. Again, it's on a case-by-case basis. It's a company decision whether or not to enroll in E-Verify or not. In most cases, especially when we're working with employers who would really benefit from hiring someone with STEM OPT, we recommend E-Verify. Our firm has registered for E-Verify. But again, I just want to reiterate, this is really an internal decision, and it depends on the particular circumstances of your organization if it's going to be a benefit to you to enroll in E-Verify, which is, we're talking about tentative non-confirmations, and I mentioned this, which is when the employer inputs the information about the individual's identity and work authorization, if something doesn't match, then internally in E-Verify, they're going to run everything through the database, and then they're going to issue a tentative non-confirmation if information does not match. This gives, then the employee has the option to contest or not to contest. If they don't contest this non-confirmation, then their employment needs to be terminated because they're saying, I'm not contesting that there's something wrong with my information, essentially. If the employee contests, then there's this notice that's provided to the individual. It's given to the employee, and they have to resolve the mismatch. And they're told on the actual document if they need to contact Social Security Administration or Department of Homeland Security. They typically have 8 to 10 federal business days to do so. So the employee has that period of time to contact the government. If they don't show up, you'll receive that information in your E-Verify account, and then the individual employee will need to be terminated. It may take a little bit of time to see the update in your E-Verify system, but typically it's pretty quick. And the final status, if everything is okay, then the employee can continue to work. If the final status from the government says that we can't match these, then if there's a final action notice provided, you would need to terminate the employee. If you continue to employ that individual after receiving a final non-confirmation notice from the E-Verify system, you could be fined for continuing to employ an individual that you knowingly know is not authorized to work in the US. So those are, a lot of the times this doesn't happen too often, but it's definitely a process where E-Verify guides employers through this. One thing that I do want to reiterate is that if there is a tentative non-confirmation, the employer should not and cannot terminate that individual unless there's for cause, right? There's other employment related reasons why somebody may be terminated, but if a tentative non-confirmation is issued, then that is not cause for termination. And in fact, the employer must allow that individual to continue to work until that case is resolved, right? So those are just some things to keep in mind. We had some initial questions prior to the webinar. Some people asked about E-Verify Plus, and I'm happy to talk about E-Verify Plus. It was on my agenda all along. E-Verify Plus is something that USCIS began testing just this past April. They have about a dozen employees right now that are in this test. And what E-Verify Plus does is it puts the burden on the employee to submit their personal data in an E-Verify app. So it doesn't take the place of employer liability. It's just a platform in which the employee completes the Form I-9 Section 1, provides, uploads copies of their identity and work authorization documents. If there's a tentative non-confirmation, that is transmitted directly to the employee. So the employer over here is unaware of anything that's going on with the tentative non-confirmation. If there is a final non-confirmation, of course, the employer would be notified. There are some concerns right now with E-Verify Plus. One is that the employer is completing the Form I-9 electronically through this E-Verify Plus program. So the employer is responsible for storing that I-9, making sure it's in compliance with all the I-9 requirements for electronic storage, also for making sure that the audit trail with respect to any actions that take place in the completion of the Form I-9 is also compliant with the I-9 regulations. And that's an additional burden on the company Right now, ICE, the specific division, which is Homeland Security Investigations, which oversees the enforcement of the Forms I-9, is working with USCIS on this audit trail compliance issue. So again, this is right now, it is just a pilot project. The Immigration Service is trying to work out the kinks, trying to get the process down. And what they're wanting to do it and what they are doing is they are working with employers that have lots of exceptions, meaning they have individuals that have a lot of different work authorization documents. So in other words, a lot of individuals who might be those non-citizens authorized to work based on some type of government authorization. So there's different exceptions, which allows them to kind of look in the back on their logic, like, okay, this person presented this document, is this acceptable? So that they can kind of get the feel for what they haven't developed in their system just yet. So E-Verify Plus is definitely being marketed by USCIS. It is out there again. It's a pilot project right now. If you are an employer that is interested in E-Verify Plus, I recommend speaking with your counsel, and then you can contact E-Verify directly to understand, the parameters of the program and what's ongoing. Now, this is moving more likely than not to some type of combined E-Verify I-9 process. So who knows what's going to happen with that? That's, in the future. Right now, E-Verify Plus is kind of one step towards maybe going into that direction to make this process simpler for employers. So just want to let you know that E-Verify Plus is not replacing E-Verify, and it's just a test program right now. So if anyone has any additional questions about that, I'm happy to answer those as well. Okay, so let's move on to our next section, which is the alternative procedure for virtual review of Forms I-9. You might notice in the new version of the Form I-9, in the additional information field, there's an additional box, and it says, check here if you used alternative procedure authorized by DHS to examine the documents. So again, only employers that are enrolled in E-Verify and are in good standing may use the alternative procedure. So if you're an employer who may have received notification from E-Verify that something is wrong, you may have been contacted by the compliance section, you might not be in good standing, but in some instances it might be a gray area, especially if E-Verify doesn't know that you haven't E-Verified the last 3 hires. Well, if you're enrolled in E-Verify and you have not E-Verified the last 3 hires, then you would technically not be an employer in good standing. So how do you get back into good standing to be able to then use the alternative procedure is something to communicate with your counsel. But again, this alternative procedure, which is something that became effective on August 1st of 2023, which I can't believe has been almost a year. That's really flown by quite a bit. But this alternative procedure is only for employers that are enrolled in E-Verify and are in good standing. Okay, so what does a qualified employer mean? Let's break down each of these requirements, right? So a qualified employer means that the employer must be enrolled in and in good standing with E-Verify. So what is good standing? The employer, and these are the criteria to show that an employer is in good standing with E-Verify. One is that the employer is enrolled in E-Verify with respect to all hiring sites that are going to use the alternative procedure to remotely examine documents. Number 2, the employer must use E-Verify to confirm eligibility of newly hired employees in the US. And the third one, which is this big catch-all, right, is that the employer complies with all other requirements of the E-Verify program. So that's where I mentioned that it could be a gray area with respect to, is an employer in good standing or not? So if there's any questions, always consult with an attorney to make sure that you're in good standing, or how you need to get back into good standing. All right, so what is the alternative procedure? So I'm going to take a step back, and if you all remember during COVID, ICE came out with COVID-19 flexibilities for the Form I-9, meaning that employers could remotely or virtually review the identity and work authorization documents of new hires, as well as re-verification of employment authorization, provided that they met certain requirements. Now, when this first came out in March of 2020, ICE had said the COVID-19 flexibilities with respect to using the remote review only applied to employers where they didn't have anybody on site. So even if they even went to even if a security guard is on site, technically you should be, having those I-9s reviewed in person. The alternative was to use an authorized representative. And that was someone who is acting on behalf of the employer to physically review the documents and complete the Form I-9 for the new hire. Then about a year later, the government changed their position and they said, well, if someone is working virtually because of COVID-19, then you can use the remote procedure. The government always had this caveat that you needed to complete the Form I-9 by this remote procedure if you met the criteria. But then once the individual came back to work on site, then their documents for identity and work authorization had to be reviewed in person and the Form I-9 updated to indicate that physical inspection was completed. And the government said, we'll give you notice before we end the COVID-19 flexibilities. Well, last year in May, the government said we're ending the COVID-19 flexibilities on July 31st of 2023, and we're giving you all until August 30th of 2023 to complete the re-inspection process, meaning if you completed the Forms I-9 with a remote or virtual review of the documents, you now need to do a physical inspection. ICE also included in their press release that we understand this is essentially a big endeavor. So if you have at least started to comply with the re-inspection process, but you aren't quite there by the end of August, we're going to take that good faith into account as long as you make that effort to do the re-inspection process and then continue to finish it up as soon as you're able to do so. So then what happened in August 1st is that the government, in its new regulation with the Form I-9, created this alternative procedure. And this, again, is only for employers enrolled in E-Verify. And that was a compromise with ICE, right? ICE wants the employers to physically review those documents in hand. We argue physical review is with your eyeballs, but they don't agree with that particular interpretation. So I said, we want everybody to actually physically in hand touch the documents when they're completing the Form I-9. ICE compromised with USCIS and said, well, if an employer is enrolled in E-Verify, there's that added layer of protection that the documents are being run through the government's database that makes ICE feel a little bit more comfortable that the individual is not providing fraudulent documents. Okay, so the alternative procedure means that an employer can review the identity and work authorization documents virtually for new hires, as well as for re-verification. So to participate in the alternative procedure, the employer must be enrolled at every hiring site in the US that allows for this virtual verification under the alternative procedure. The employer also has to offer this consistently to employees at a hiring site or to no employees at that hiring site, right? It has to be consistent. And IAR has also stepped in with respect to the anti-discrimination and said, if an employee says, I don't want to do this alternative procedure, I don't want to provide my documents virtually, then the employer has to accommodate that by completing the Form I-9 in person. And that would either be specifically at the employer's work site or with a direct employee of the employer or through an authorized representative. The other requirement is that the employer's E-Verify users must have undergone an E-Verify tutorial that includes fraud awareness and anti-discrimination training. But note that if an employee was already enrolled in E-Verify as an administrator or a user and went through one of the training programs, they didn't have to do this additional anti-discrimination training. So that was like a little bit of a loophole there, but those are some of the requirements. So once we know that an employer is okay to participate in the alternative procedure, what is the process? Right, so the employee is supposed to send the front and back, if it's the two-sided document, just to be ultra conservative, because you never know if there's nothing on the backside of a document unless you have a copy of the backside showing it's blank. We just recommend, for consistency's sake, you tell the employees to provide us with a copy of the front and back of your document or documents that you're presenting for identity and work authorization. The employer then will examine the copies of the documents to make sure that what's presented appears to be genuine. And then the employer is to conduct a live video interaction with the employee. So that can be, FaceTime, it can be Zoom, WebEx, Microsoft Teams, anything that is video interaction. The employee is required to provide and put up to show the employer the same documents that they provided copies of. If the employee says, oh, I provided you with a copy of my passport, but I just lost my passport, then you need to essentially stop the video interaction, have the employee upload the new document or documents that they're going to present, and then start the video interaction again, right? Because you always have to have the documents uploaded, viewed by the employer, and then do the video interaction with the employee. Once that video interaction has been completed, in section 2, documents information have been inserted, then the employer is going to mark the box on the Form I-9 that the alternative procedure was used to complete section 2 with the review of the documentation. So the employer, you want to make sure that you're consistent with the regulations, that you have to maintain clear and legible copies of the documentation as part of your I-9 process, right? And then you also need to make sure you complete, the Form I-9 and E-Verify as you normally would. So that's like the process. We recommend making sure that you have that process outlined so that everyone knows what the steps are and who's responsible for each step of the process. I'm going to go over just quickly the increasing list of acceptable documents. And what I mean by this is that on the Form I-9, there's the list of acceptable documents, which shows what an employee can present as proof of identity and work authorization as a List A document, or they would provide a List B document to show identity, plus a List C document to show work authorization. What the Immigration Service did is they provided links on this list of acceptable documents to their I-9 Central, as well as to the section that talks about automatic extension of employment authorization documents. It's important to know that this list of acceptable documents, or what we refer to as the load, must be presented and given to the employee when completing the Form I-9 so that they can review what documents are acceptable for them to present. Why I say it's an increasing list of acceptable documents is that there are currently more than 40 documents that may be accepted for I-9 purposes that are not explicitly stated on this list of acceptable documents, which is included with the Form I-9, right? So some examples are expired EAD cards, which stands for Employment Authorization Documents, that have been automatically extended. So our government initially did a 180-day automatic extension of the EAD cards because they could not process these applications fast enough. If you remember COVID, post-COVID, there was a tremendous backlog at USCIS, specifically with the production of these EAD cards. So they did automatic extension of the EAD card for 180 days, and then another one for 540 days. It's currently 540 days. There's also expired EAD cards for TPS that have been extended by the Federal Register notice, or timely filing a renewal application, or they could have been issued an individual notice by USCIS. And then there's also work authorization that's been granted specifically for situations such as United for Ukraine and Afghans. And then the other thing that's not on List B that employers can use is a temporary driver's license that contains a photo or identification such as name, date of birth, etc. And then also those wonderful cards, the Nexus, the Sentry, Global Entry, they may be used as a List B document as well. So if just looking at the list of acceptable documents right now might not be sufficient. There's additional work that might be needed to go on to I-9 Central or to communicate with an attorney to see if a particular document is acceptable, because you really don't want to get into that anti-discrimination issue with IER. Right? Okay, so the last section, and then I see that we have some questions here, so I will go through those questions as well as many as I can get to, but I'm just going to finish up with internal I-9s. So with internal I-9s, there's, one of the things to think about is an internal I-9 audit, right? An internal I-9 audit is completed by an organization internally to kind of take the health of your I-9s. If ICE, Homeland Security Investigations, comes knocking at your door, are you hopefully going to have really good completed Forms I-9 so that you're going to walk away with, you did a good job, or maybe there's a few errors and you get a warning notice. What you want to avoid, if at all possible, is being fined by HSI. So if you're going to conduct an internal I-9 audit, we recommend, doing a healthy internal I-9 audit once a year. If you're a larger organization, you might want to do this on a quarterly basis, take, a 25% of the employees each quarter so that you're not having to do this huge project at the end of the year. And you want to make sure that you set up steps so that you're consistent with your internal I-9 audit, and that you're making sure that you're abiding by all the rules. We recommend, not because we're attorneys, but if you're working with an attorney for an internal I-9 audit, there's attorney-client confidentiality, which doesn't exist via working with an HR consultant, but there are all different ways to do an internal I-9 audit that might help you with just doing an internal check. So first of all, determine the purpose of the internal I-9 audit. Is this because you just want to make sure that your I-9s are healthy? Also determine the scope of the internal I-9 audit, right? Are you going to audit all of your I-9 forms or just a subset? For instance, just a division or just a worksite location. You also want to communicate with employees, because as part of the process, you might find mistakes that employees are going to have to be called in to correct, if it's on Section 1. So it's always good to have that communication with the employees to let them know you're conducting this, and they may be that you might reach out to them for information or for their assistance. Again, to avoid IER, you want to avoid discrimination and any kind of retaliation. And then make sure that you create a process for correcting errors or omissions that have been found on the Form I-9. So what you'll initially do is gather all of the Forms I-9 to be audited, right? You want to ensure that there's a Form I-9 for every employee on payroll. So you're going to look at your payroll and then make sure that you have I-9s for every person on that payroll. If there isn't an I-9 for someone who's on the payroll, then you want to make sure that you get that I-9 completed as soon as possible. And one of the easiest ways to go through the Form I-9 is to audit it section by section. And remember, employers can make corrections to Section 2 only, and employees can make corrections to Section 1 only. If you're doing your corrections via hand, right, with a pen, you always want to make sure that you use a different color pen. If at all possible, it's super helpful to know when the correction has been made. And you also want to always initial and date your corrections. If there's an audit that's being done through an internal I-9 program, then you want to make sure that any changes to the Form I-9 are noted via the audit trail. ICE, specifically Homeland Security Investigations, wants to make sure that they know who did what and when they did it, so that nothing is backdated, nothing is whited out, nothing is done on the down low. You want to make sure that it's very clear that these edits have been made. And then the last thing that you want to do is determine when Forms I-9 for terminated employees can be purged, right? So those are some things to consider with doing an internal I-9. Why did I go over internal I-9s? Well, because the civil penalties for just simple paperwork violations right now are between $281 and $2,789. If there are, a lot of mistakes, then you might be fined at the higher rate. So Homeland Security Investigation, which is HSI, can increase or decrease the total fine based on aggravating or mitigating factors. One thing to note that in fiscal year 2019, HSI conducted almost 6,000 I-9 inspections, and they reached $14.3 million in fines, penalties, and forfeitures. Now, fast forward to the last couple of years, fiscal year 2022, HSI conducted 624 audits. Fiscal year 2023, they conducted, and I apologize, this is a typo. I'll make sure we get this fixed before we send it to everyone. There's 301 audits. And then right now, HSI has said that they're on track to audit approximately 30 employers for this fiscal year 2024. The audits are now lead driven, which means that HSI is really honing in on those industries that tend to have problems with their I-9, that tend to employ individuals without work authorization. So even though they're auditing fewer employers, they are still fining at about the same rate, they said. So those are just some things to consider, right? This is a matrix. It has the old fines because this is one specifically from a notice of intent to fine that was issued to an employer. And you can see that what ICE does is they look at the percentage of forms I-9 that have violations in order to determine the fine amount. So if 50% or more of your I-9s are going to have violations, then yes, you're looking at that correctly. That's over $2,000 per form I-9 in fines, right? So that's something to be really concerned about. Next slide, please. And then I mentioned HSI can either increase the fine by up to 25% or decrease the fine by up to 25% by looking at the business size, the good faith nature of the employer with how they completed the forms I-9, the seriousness of the violation, whether or not there were any unauthorized documents, and was there a history, meaning has the company been audited by ICE in the past, and did they have a warning notice, or did they previously get a fine? So those are the factors to consider. So just quickly, when you're correcting mistakes, and these are if you're hand correcting mistakes, you want to make sure that everything is documented, right? Every change is initialed and dated, and only the appropriate representative or the employee corrects on the actual form itself. If the corrections are being done through an electronic I-9 software program, you need to make sure that it complies with the audit trail requirements. Again, we just want to say it's never too late to correct your I-9s, to complete an I-9 if you find that it's missing for an employee. Never delete, never white out, never black out, and never, ever, ever backdate. You're going to get yourself into more trouble with HSI if you do any of these things with respect to using whiteout, deleting, backdating than you would if you just made the correction. Our retention rules, right? So forms I-9 are retained for all active employees. After an employee has been terminated, again, after an employee has been terminated, an employer may purge the form I-9 based on this formula. So it's 3 years after the date of hire or 1 year after the date of termination, whichever is later, which is a document that immigration or USCIS had that I have employers use this to fill it out if it's helpful to them to keep track of the forms I-9. Electronic software, I-9 software programs will actually complete the formula for most forms I-9. So once an employee's employment has been terminated, then go ahead and determine when you were able to purge the form, because ICE cannot fine for a form that has been purged. But if you maintain a form that could have been purged and ICE requires that in an audit, you will have to provide it, even if you could have purged it. So those are some things to consider. Right, so with that, I'm going to go through as many questions as I can in the 8 minutes that we have left. Let me see, let me go through these. So if an employee was hired in 2022 and early 2023 prior to the new form being required, would you need to redo the original Form I-9? No, you won't need to redo the original Form I-9. If you did it on the version that was acceptable during the time that the employee was initially hired, then that would be completely fine. You don't need to redo on the new Form I-9. So when can you use a Spanish document in Puerto Rico and not other places of the US? isn't this discrimination, not giving the potential employee a language translation opportunity? So the government itself has said that the Spanish language version of the Form I-9 may only be used by employers that are located in Puerto Rico. If an individual does not, English is not their first language, then a translator may be utilized in order to help the employee complete Section 1, and then that translator would complete the Supplement A as being the translator. Okay, all right, next question. Can you ask for a driver's license as one of the I-9 documents if a driver's license is a requirement for the position due that they will be driving clients out in the community? So this is a really good question. And what I want to reinforce here is that you want to make your I-9 process completely separate from any other process that you have for onboarding. So when you're looking at the I-9, you're looking at telling the individual, I need you to complete Section 1. I need you to provide me with a List A document that evidences your identity and work authorization, or a List B document to show identity, plus a List C document to show work authorization. The employee has to have absolute control and the ability to provide whatever document or documents it is that they want to perform I-9 purposes. And then once the Form I-9 is completed, then you can turn to the other documents and say, now I need your driver's license because you're going to be driving, and it's a requirement of this company for you to provide us with your driver's license. So make sure that they are completely separate. IER will definitively say that if an employer asks an employee for a driver's license for completing the Form I-9, that is a form of document abuse and could also be potentially run into discrimination issues. It's a good issue to bring up. All right, is there a benefit to completing the I-9 for contracted 1099 employees? No, absolutely not. Only complete the Form I-9 for those who are employees. Independent contractors, you do not complete the Form I-9. Would never recommend that. Let's see. If your business operates on a 24/7 schedule, does the 3 business day rule stand? So if an employee starts on a Friday, is Section 2 due on the following Monday or Wednesday? So the section or the 3-day rule still stands. I would have, I would also talk to an attorney to see if you don't have HR personnel or the appropriate personnel who would normally complete the Form I-9 there on the weekend, then maybe there's an exception to that, but definitely, that 3-day rule is there for the 3 days that the individual is working. But I would ask for your specific circumstance to just check internally with an attorney to see how you might want to handle that and any kind of documentation that would be necessary for that particular issue. So that's one that I would say just discuss with counsel. Right. Can Section 2 be completed before their first day of work if you're reviewing I-9 documents on a video meeting? So yes, Section 2. So Section 1 and Section 2 can actually be completed before the first day of employment, as long as you consistently do that for all individuals. So the key is consistency. So if the individual provides you with the copies of the documents as required for the alternative procedure, you can complete Section 2, but then I wouldn't sign as the individual who's reviewing the documents and doing that video interaction. You don't want to sign Section 2 and act until you've actually had that video interaction with the employee, right? But you could physically, complete the information in Section 2. With an electronic I-9 program, I get, talk with that provider because sometimes you need to complete it all at once. But that's the caveat with that. Always be consistent though with completing before, so that it doesn't look like individuals are being, pulled out for a different process than anybody else. Okay, we utilize an electronic I-9. How do you complete the Supplement B portion of the form? What are some reasons to complete the Supplement B? So Supplement B is, one of the pages of the Form I-9. It would be completed, let's say that you're rehiring somebody within 3 years of when the Form I-9 was initially completed. Their work authorization is still valid, then you would just put the rehire information in Supplement B. If you have an individual, again, I don't mean this in a bad way, but I refer to section 1, box 4 is for individuals that have temporary work authorization. So in those situations, if somebody provides you with temporary work authorization, so think your H-1B employees, TN employees, J-1 employees, individuals with optional practical training, so those are the F1 students, or STEM OPT, those individuals have authorization to work that expires, so you would use supplement B to re-verify their work authorization. Right, and then I think we have time for one last question. Is it mandatory to complete supplement B for someone who gets married and provides their social security card with their new last name? Nope, you wouldn't, sorry. Supplement B, you can include that information about a name change. So the name change can be that you would include that information in supplement B, but you wouldn't include the document information. You would just note that there's been a name change in supplement B and then sign and date it.
All right.
Where I think we're there. I think we hit it.
Thank you for joining us today, Kimberly. I'd like to thank you for being with us and providing us with such an informative and timely presentation.
Happy to be here. Thank you, everybody.
If you have any questions about our I-9 solution, you can scan the QR code on your screen. As a reminder, we will share the webinar continuing education unit information and the recording via email in the coming days. Thanks again for joining us and have a great rest of your day, everyone.